presenting a joint submission from the Fiji Women's Rights Movement and the Fiji Women's Crisis Center. The current Electoral Registration of Voters Act amendments require Fijians, when applying for registration as a voter, to provide, amongst other things, the applicant's full name as specified on their birth certificate and to provide a copy of their birth certificate. Prior to this, a Fijian could apply and be registered as a voter under an adopted name, including family name adopted on marriage, or any other name by which they like to be known, provided they could establish an identity without formally recording a change of name in their birth certificate or by deed poll. The new laws require Fijians to use only the name on their birth certificate for voting and other official purposes, including for official identification documents. Under the new and existing laws, Fijians who wish to use their married name or adopted names for these purposes must formally change their names on their birth certificate in order to do so. A consequence of this is having to also change multiple identity documents. On Thursday, 30th December 2021, 7 women supported by the Fiji Women's Rights Movement and the Fiji Women's Crisis Center filed a constitutional redress case challenging the name change laws recently passed by the government. The laws which are under challenge make changes to the Electoral Registration of Voters Act and the Interpretation Act 1967. The 7 women include Yasmin Khan, Aselina Davila Tomanivalu, Lavinia Rose Benedict Rounds Ganglau, Shiramani Priscilla Singh, Elizabeth Catherine Reed Fong, Lemba Sainimbo, and Salote Raikolo Ngalo. We are still awaiting that judgment. We, the Fiji Women's Rights Movement and the Fiji Women's Crisis Center, call for the repeal of this legislation for the following reasons. The new laws are gender discriminatory because they disproportionately impact married women's right to choose the names by which they wish to be known in a way that is different to men and unmarried women. We strongly object to the new requirements in the new laws as it has a disproportionate impact on married women. Withholding the right to choose from married women is in breach of their rights and is not a choice imposed on married men or single unmarried women. If married women formally register their adopted names, it will force them to completely abandon the name given to them by their parents and their natal family name. On the other hand, if they do not formally change their names and revert to their birth names, they will be abandoning their acquired family names. For married women, being forced to choose one or the other will mean that they will be breaking a cherished, long-standing tradition of dual identities, identifying with their husbands and children, as well as with their parents and extended families. Being forced to choose means they will be abandoning one form of a cherished identity for no lawful reason. The second reason is the new laws place significant burdens on married women. If a married woman chooses one option, the name on their marriage certificate and on their children's birth certificate and all other documents and records in existence, such as titles, wills, etc., will not match the one on their birth certificate. The new laws forces married women to spend large amounts of their time to visit the government offices to formally change their name. Or if they decide not to formally change their name to their registered name, they would similarly have to take even more significant amounts of time to change a number of other important legal registrations and documents. As women, we bear a disproportionate burden of domestic and care responsibilities compared to men, and having to expend large amounts of time changing names on various documents will increase their time poverty compared to men. The third reason is the new laws threaten married women's legal and political rights. It is the duty of the state to protect democracy, human dignity, equality, and promotion of human rights for all individuals and communities in Fiji, particularly where these are threatened by state action and where the subjects are members of a group such as women that have historically been treated unequally, have endured systemic sex and gender discrimination in all spheres of life, and have not enjoyed full human rights. The new laws remove the right of married women to use family names which they had lawfully adopted and by which they are known in their community for political purposes, and to retain their birth name on legal records and to use it for other purposes. The new laws restrict the freedom of choice that married women previously had. Due to the need to make and register a choice in order to obtain a new voter identification and to remain on the NRV and to vote, the new laws impose a restriction on those rights which were formerly freely exercisable. There is also the fact that the new laws did not allow time for them to decide and make changes, and the imposed restriction with immediate effect. The fourth area is that the new laws serve no legitimate purpose. The new laws do not serve a legitimate purpose, and in fact, Fiji has had 2 general elections under the present constitution, both of which were won by the then ruling party, and both were found free and fair by international observers. No specific problem in respect of previous elections had been identified by the previous government that would be eradicated by the new laws. Accordingly, no proper legitimate aim has been established. The Electoral Registration of Voters Act 2012 and the Electoral Act 2014 already contained adequate provisions to ensure that there were no fictitious identities, no double voting, and no impersonation. Voters were already required to provide a residential address, occupation, date of birth, gender, thumbprints, facial photograph, as well as other acceptable identification to register under Section 4 of the Electoral Act 2012. And these details were to be entered on the NRV under Section 9. The computer programs can easily assist to identify double registrations from names, occupation, addresses, date of birth, fingerprints, and photos. These details provide more than adequate means to verify identity and to prevent fraudulent and double registration in voting. Fiji may well already have many means of identification. Section 51 of the Electoral Act 2014 also requires a voter to use a voter identification card or some other acceptable identification to vote. In addition, it also requires that indelible ink be applied to the finger of a voter to show that he or she has voted, and if the finger is marked already, if a voter seeks to vote, no ballot paper can be given to the voter. These are adequate further methods of preventing impersonation and double voting. There is no evidence that shows that despite these safeguards, the past elections were not free and fair. There are no evidence to show how the new requirements to provide a birth certificate name will enhance administrative convenience or improve on the freedom and fairness of elections. A birth certificate is not proof of eligibility to register or vote. It shows details of one's birth, not of one's citizenship. It does not contain a photograph, so it is possible for someone to provide and use someone else's birth certificate for voting purposes, for example, the birth certificate of someone who is overseas. In fact, one could argue that it encourages voter fraud. It is therefore submitted in the absence of any justification of a legitimate aim of the new laws from the defendants of the case that we had. And the next area is that the new laws breached married women's right to privacy and cultural identity. In Fiji, a large proportion of women in all ethnicities in Fiji have adopted their husband's surnames as their family name upon marriage. while it is not customary for men to adopt their wife's name as a family name. The husband's surname becomes the family name, which married women share with their children. At the same time, married women also value the original natal names given by their parents as part of their cultural and social identity and familial heritage. Married women, when adopting their family names, did not renounce their original birth names, which for each of them remains an important part of their identity, as this was allowed by law. The rights to personal privacy and dignity are enshrined under Section 24 of the Constitution, and in particular their right to respect for their family life. The wish to be able to retain their original name on their birth certificate as a record and expression of their identity as members of their natal family, while using an adopted family name for their own family unit and descendants. A person's name is an integral part of one's identity, and this is agreed upon by the Human Rights Committee, which is charged under Article 41 and 42 with advising and enforcing the International Covenant on Civil and Political Rights, and the European Court of Human Rights have ruled that a person's name falls under the protection afforded by the right to the respect for private life. A person's surname constitutes an important component of one's identity, and that the protection against arbitrary or unlawful interference with one's privacy includes the protection against arbitrary or unlawful interference with the right to choose and change one's own name. The new laws breaches the right to privacy for married women by requiring them to choose one name and to go through a burdensome administrative process to record their choice. And the new laws require them to choose between the birth name of their original natal family and the family name of their immediate current family. This clearly interferes with their existing right to choose a family surname for one purpose while retaining birth names for another purpose. The next area is that the new laws breach the Convention on the Elimination of all forms of discrimination against women, CEDAW, and other human rights international norms. Fiji is party to CEDAW, ratified in 1995, and this means that the Fiji government recognizes that women have been historically and systematically disadvantaged in all spheres when compared to men, including legal rights and political life. It imposes obligations on the state to take measures to eradicate that historical inequality. The new laws breach women's right to equal protection and freedom from unfair discrimination because of the disproportionate effect of the new laws on them as married women. In conclusion, it is the responsibility and the duty of the government under the Constitution to advance human rights and equality between men and women. Women, in particular, married women, have historically been discriminated against directly and indirectly in the enjoyment of their legal and human rights. The Constitution and international laws such as International Covenant on Civil and Political Rights and Convention on the Elimination of all forms of discrimination against women require the state and their courts to take an active role to promote equality in the enjoyment of the rights by women, including voting rights. The new laws prevent a very large disproportionate number of married women from exercising their legal and voting rights at all unless they take steps that are costly in terms of time and money, which men generally do have to take in order to exercise their rights. Although the state has the duty to promote women's participation in elections and in the enjoyment of their right, the new laws do the opposite. For all the reasons outlined, we strongly recommend that the new laws be repealed, as the state has provided no justification that the new laws were necessary, reasonable, or proportionate, nor did they provide justification on the impact it had on married women. Thank you.